Now, the last point I wanted to mention, I want to leave some time for discussion, is about what is happening under the Nagoya Protocol. Now, I'm not sure how many of you know about the Nagoya Protocol or what it is about. I think even experts on the Nagoya Protocol don't necessarily know exactly how this regime will work. It's still very much, I think, work in progress. And again, many of the drafting, the open-ended drafting that we find in the convention is certainly there also in the protocol. But the one aspect I want to discuss with you is the fact that the protocol, among other things, has consolidated the entitlements of indigenous and local communities under the convention to the sharing of benefits with them from the use either of their traditional knowledge associated with genetic resources, or even the genetic resources themselves that are held by those communities. Now, I've put those two provisions there. Probably it's needless to say that these are very not controversial provisions as such, but their application, their relevance to different Nagoya Protocol parties is quite controversial, and you can see from the drafting that there are quite a significant level of caution in establishing this link. And there are other provisions in the protocol that relate to indigenous peoples and local communities in terms of their prior informed consent or approval and involvement, but also in relation to the consideration of the customary laws in the implementation of the protocol, is that, of course, if we move from an MEA that is purely based on interstate obligations to one where we have, at the very least, a clear stake, if not, according at least to some commentators, almost the creation of rights for indigenous peoples and local communities, then again, a compliance system that could be created should also factor in that element into its procedures. And in fact, during the negotiations of the compliance procedures under the protocol, several perhaps more groundbreaking suggestions were made to really say, well, we can't just take the usual MEA compliance approach here. We should either look into how human rights instruments work and the submission of complaints there, or we should look at how the Aarhus Convention works, and definitely making, perhaps even considering either a community trigger to the compliance system, or some other ways for also these provisions whose beneficiaries are non-state actors to really be somehow have access to the compliance system. Now, of course, parties were quite concerned about this development, and in fact, I mean, if you compare those provisions in the Nagoya Protocol, they don't really necessarily match what we have in the Aarhus Convention and the much clearer right-based approach that we find there. So there were different views among parties as to whether and how communities should have some access to the compliance mechanism. And eventually what we see is quite a few entry points, let's say, for communities in the procedures, but not a community trigger, as it had been suggested. And again, it remains to be seen in the practice whether or not those doors into the system will make a difference or not. I mean, in all events, I think this is quite a unique approach in MEA compliance procedures, so it's worthy of a bit of attention. So we have the possibility for some committee members to be indigenous peoples and community representatives, but that may or may not be the case. And we have also the possibility, and that's actually an obligation, for two community representatives to be observers, which means that they will be able to participate in the discussions, but not in the taking of decisions within a compliance committee. Now, while the communities themselves can't bring information to the compliance committee and trigger a procedure, the Secretariat may receive information from a directly affected indigenous or local community. Now, so it's almost an indirect entry point for communities, and it's qualified in two ways. First, there's only certain matters that on which information can be brought to the attention of the Secretariat. It has to do with the completeness and accuracy of information of national reports. So of course, if the country is reporting on matters that are related to the communities themselves, their knowledge, their customs, the communities would have a sense of whether or not the state is being accurate in portraying that information. Same goes for the information that the countries will have to provide to the ABS clearinghouse. And finally, also something that's related also to national implementation, but it has not to do with information, it's with how countries deal with their obligation to take into account customary laws of indigenous and local communities in their implementation of the protocol related to traditional knowledge. So limited set of matters for the information to be submitted, and the Secretariat also is not supposed to transmit that information right away, but it has first to engage in a discussion between the state concerned and the community and try and clarify the issue. So there's a sort of mediation and cooling off period into which the Secretariat works with the party and the communities before deciding whether or not that information will be forwarded to the Compliance Committee. Another interesting element of the procedures is that the committee itself may, of its own initiative, seek information from indigenous and local communities, but it has somehow to assess whether that information can be considered reliable. So there's a filter there. Not any information provided by ILCs, even if it is done at the initiative of the committee, may be just brought to its attention and analyzed, but somehow the reliability of that information has to be ensured first. And then there's again perhaps an indirect way to consider indigenous peoples and local communities issues. Again, it's the initiative of the committee. It may seek advice from independent experts, including an indigenous and local community expert. Now, it's not clear whether the expert needs to be him or herself a community member, but there is an understanding that because the obligations in the protocols really not only go beyond the interstate relations, but also deal with, again, an extreme variety of situations of customs and relationships of very different groups of indigenous and local communities out there, that is something that would normally go beyond the type of expertise that you would have on an MEA compliance committee, will be extremely complex and probably unique and will require particular expertise. And the final possible opening, although this is just my argument, but the committee may also, if it is invited by the party concerned, conduct information gathering on the territory of that party. And I would imagine that based on the practice of other international bodies, particularly in the human rights arena, so think about the special rapporteurs, those country missions may provide an opportunity for the committee to hear the views of indigenous and local communities. Right. The only last thing perhaps I wanted to mention is what are the measures that the Nagoya Protocol Compliance Committee can adopt. In some ways, they're quite classical, but you have that element which we find in more modern MEA compliance systems of the action plan. The idea that what is helpful is to have a structured dialogue with the party about specific steps and agreed timelines and perhaps even indicators to assess progress towards implementation, with the party having possibly to submit progress reports. This is something that the committee may do on its own, whereas there are in addition to those measures, there are other measures that only the Conference of Parties will be able to recommend. So either the provision of specific assistance, be that financial or technical or technological, the issuing of written caution or, let's say, different expressions of concern by the COP. And finally, there's this Sibyllene clause about possibly other measures as appropriate and in accordance with the general rules of international law, bearing in mind the need for serious measures in cases of grave or repeated non-compliance. So while everything that we have here is more or less business as usual, there is an opening there depending on whether or not situations of non-compliance may arise and their severity, that the COP itself may consider further measures and recommendations. And this is because, going back perhaps to the interstate nature of the obligations in the protocol, what we see is a very, it's almost a heightened level of bilateral cooperation among parties. So some aspects of the Nagoya Protocol will be implemented by the whole membership of the protocol, but it is expected that the provider country, the country providing genetic resources, and the country where those resources will be used for research and development, they will have to work quite tightly in the exchange of information, in monitoring, in even the actual ensuring the compliance by private operators. And that tight cooperation will really rely on the goodwill and the genuine efforts made by both parties. And without really the work of both, the whole idea of the protocol and the idea of tracking and understanding how those genetic resources are developed into products commercialized, and how some of that financial or non-monetary benefits may then return to provider countries, and hopefully to some degree also contribute to conservation and sustainable use. All of that high level of cooperation may need perhaps additional measures than the normal ones we have in other MEAs for it to really operate in practice.